Okay, let's unpack this. Sometimes the biggest shifts in these really complex legal situations don't happen with, like, a huge courtroom reveal.
Right. Sometimes it's just one document being filed quietly.
Exactly. And that's what we're diving into today. We've got source material here focusing on a specific legal filing. It's a declaration from James Vituscka.
And it's a part of this ongoing, pretty significant lawsuit. gov.uscourts.nysd.634304. For anyone tracking, document 286.1 is the one we're looking at.
And it involves some well-known names mentioned in the sources. Leslie Sloane, Justin Baldoni, Blake Lively, Bryan Freedman. Quite a few.
Yeah, it's a complex web. The backdrop, as the sources describe it, is this lawsuit where there are various claims flying around, including defamation. Leslie Sloane is definitely one of the key figures caught up in that.
So our goal today, really sticking to the sources we have in front of us, is to break down what this Vituscka declaration actually says.
What it reveals, yeah.
And why the source material is calling it things like a bombshell. What are the ripples? What could it mean for everyone involved? Again, strictly based on what these sources are telling us.
Precisely. We're pulling out the core claims from the declaration as discussed in the sources and trying to understand their weight within the lawsuit's context, again, as described in our material. It's about seeing how this single piece might just change the game.
All right, let's get right into it then. The James Vituscka declaration. What's the absolute core message, the main point, according to the source material?
So the central thing, and the sources really emphasize this, is that this declaration aims to correct the record. Specifically, it's about whether Leslie Sloane ever called someone a sexual abuser.
Okay, a really serious allegation, and this declaration is setting the record straight on that.
That's what the source material indicates. It directly addresses and, well, disputes or clarifies how that accusation against Sloane was previously presented in court filings.
So what is the correction? What does Vituscka actually say happened, or rather didn't happen, according to the source?
Fundamentally, the declaration clarifies that Leslie Sloane did not make that specific sexual abuser claim about Justin Baldoni back in August.
August. Okay, that date seems important. Why is the timing such a big deal here?
It's absolutely critical based on the source discussion, because apparently previous court filings had sort of positioned this alleged statement by Sloane as happening back in August.
Ah, I see. So it wasn't just what was said, but when it was supposedly said, and by whom.
Exactly. The source material really breaks this down. It points out that the message from Vituscka that did contain that sexual abuser phrase actually happened way later, in December.
December, not August.
Right. And crucially, the source says this December message was from Vituscka himself, and it was referring to the CRD.
CRD, remind us.
Civil Rights Division complaint. So a formal report about alleged civil rights issues made to the authorities. Not, as seemed to be the implication in earlier filings according to the source, some comments Sloane made directly about Baldoni back in August in a, defamatory way.
Wow, okay. So the declaration says, wrong person, wrong month, wrong context. It wasn't Sloane in August about Baldoni. It was Vituscka in December about a CRD complaint.
That's the gist presented in the source, yes. And the source emphasizes this, completely changes the narrative that those earlier filings were apparently trying to build, maybe suggesting Sloane was planting negative stories early on, using that August timeframe.
That is a huge difference. If the person who wrote the message steps up and says, hold on, that's not what happened. That wasn't Sloane. It wasn't then. It was me later about something else. That feels incredibly significant.
It does. And there's another layer to this mentioned in the source material about that December message from Vituscka.
Oh, yeah. What's that?
The source includes the detail that this message, the one from December, about the CRD, was apparently published in court filings without his authorization.
Wait, what? Without his... Okay.
That's what the source material states. It adds this whole other dimension, suggesting maybe his private message was used in court documents in a way he didn't agree to.
And possibly, according to the source, positioned to back up a timeline or story he now says is wrong.
Exactly. It raises questions about how that communication ended up in the filings and presented in that context.
Published without his authorization. That phrasing alone, if accurate as reported in the source, is pretty explosive. Does the source give any insight into why Vituscka decided to come forward with this declaration now?
It does offer a perspective. The source material presents it as Vituscka willingly providing this declaration and information to Leslie Sloane's legal team.
Willingly?
Yeah, willingly. The discussion in the source suggests he seems to be telling a truth as he sees it, wanting to set the record straight.
Okay.
And furthermore, the source details discussion suggesting Vituscka felt, and these are strong words reportedly used in the source discussion, fucked over by Bryan Freedman.
The lawyer for the plaintiffs, including Baldoni.
Right, and potentially felt set up by Sarah Nathan, who's another figure mentioned, regarding how his December message ended up being used in those filings.
So, the picture the source paints is Vituscka feeling like his words were twisted or misused by the other side.
Which then prompted him to cooperate with Sloane's team to correct the court record. That's the strong impression given by the source material.
So not just a neutral witness, but someone with a perceived grievance driving this correction, according to the source.
That's definitely the angle presented in the discussion we reviewed. He's actively trying to fix what he seems to see as a misrepresentation involving his own words.
Okay, so understanding what the declaration says, and according to the source, why Vituscka filed it, let's talk impact. What does the source say this does immediately to that defamation claim against Leslie Sloane?
This is where the source uses really, really strong language. The immediate takeaway highlighted is that the defamation claim against Sloane, specifically the one tied to that alleged August sexual abuser comment, is seen as basically collapsing.
Collapsing how?
Phrases used in the source discussion include unraveling, dead, deceased, over, and pretty much over.
Wow. Dead, deceased, over. That leaves very little room for doubt about how the source views the state of that claim now.
Not much ambiguity there now.
Why is it seen as so fatal? Why does this declaration just kill that specific claim against Sloane, according to the source?
Because, as the source explains it, that whole claim against her seems to have been built almost entirely on the idea that she made that specific comment in August.
Right, the foundation.
Exactly.
Yeah.
So when the guy who actually wrote the message with similar words comes forward and says, under oath in a declaration, nope, that was me. It was in December. It was about the CRD complaint, and Sloane did not say that in August. Well, the factual basis for accusing her just evaporates.
Poof.
Pretty much. The source indicates the declaration just pulls the rug right out from under that specific accusation.
And the source also mentions how this claim against Sloane was viewed even before this declaration came out, right?
Yes, the source includes a pretty strong view that this particular claim against Sloane was bogus and clearly frivolous right from the beginning.
Frivolous? Why frivolous?
The reasoning presented is that checking the facts should have been simple. Like, just ask Vituscka, the guy who wrote the message, hey, did Sloane say this in August?
Seems straightforward enough.
Right. The source suggests the failure to do that basic check before putting the claim in a lawsuit points to it being, well, improperly brought. Frivolous.
So the feeling in the source is this wasn't some hidden detail. A quick check could have cleared it up. Filing the claim anyway, only to have it debunked like this, is what leads the source to call it frivolous.
That's the connection being made, yes.
And the source even floats a theory about why Sloane might have been included in the lawsuit at all if this core claim against her was apparently so shaky.
It does. There's speculation discussed in the source that the only reason Sloane was named as a defendant was because of this specific and now seemingly debunked claim about the August comment.
Seriously, just based on that one thing.
That's the suggestion presented in the source. That maybe her inclusion wasn't about solid facts against her, but more of a strategic move. Maybe target a high-profile publicist or for other reasons we might get into. It makes the case against her look, according to this view, potentially strategic rather than purely fact-based.
Wow. Suggesting someone gets dragged into a massive lawsuit based mainly on a claim the source of the quote says is wrong. That's a pretty stark interpretation from the source about the plaintiff's strategy.
It is. And given all this, the source understandably talks about how Leslie Sloane must be feeling.
I can only imagine. What does the source say?
Just that she must be feeling immense relief. I mean, to be publicly accused of something so serious, have it be the basis of a lawsuit,
Yeah.
and then have the guy who wrote the actual message clarify it like this. The source suggests it must be a huge weight lifted.
Absolutely. You can see why relief would be the word. Okay, so if the claim is seen as dead, what happens next legally for Sloane? What recourse does she have, according to the source material?
Right. If the claim is potentially frivolous, the source discusses the strong possibility of her seeking payback, legally speaking.
Payback how?
The main thing discussed is her seeking to recover her legal fees from the plaintiffs who brought the claim against her.
Makes sense. If you had to defend yourself against a baseless claim, you'd want your costs covered. How does the source say she'd do that?
The source specifically links this to something called a Rule 11 motion.
Rule 11.
Yeah, Rule 11 of the Federal Rules of Civil Procedure. Basically, it says lawyers and parties have to make sure their court filings have a real basis in fact and law and aren't just filed to harass someone or drive up costs.
Okay.
If a filing violates that rule, if it's found to be frivolous, the court can impose sanctions. And those sanctions often include making the violating party pay the other side's attorney fees and expenses caused by the bad filing.
And the source says Sloane might file one of these Rule 11 motions.
It suggests it's highly likely. And it points out she kind of already laid the groundwork by demanding legal fees way back in her initial motion to dismiss the case against her.
So she signaled this intention early on.
Seems so. And now, with this Vituscka declaration seemingly proving the factual basis was faulty, as interpreted by the source, that Rule 11 motion arguing the claim was frivolous looks like a strong possibility.
Who would she target with that motion? Who pays the fees?
The source discussion suggests the motion would likely target all the Wayfarer parties involved in bringing the claim, including Justin Baldoni.
And the argument would be?
The view presented in the source is that the failure to do a reasonable check, just asking Vituscka before filing, is mind-boggling. That plus how the message was allegedly twisted in the filings to fit a narrative. The source says that fits the very definition of a Rule 11 frivolous lawsuit against Sloane.
That's a direct quote from the source discussion. Very definition of a Rule 11 lawsuit.
Yes, reflecting a very strong opinion within the source material that the plaintiffs could be on the hook for Sloane's costs here.
Powerful stuff. The source mentioned another rule number 2, didn't it? Something else potentially relevant.
Yeah, there was a brief mention of Rule 47.1 in the source discussion. Something about filings involving sensitive issues reported by non-victims, I think.
Okay.
But the source itself noted there were questions about whether it really applied here. So we should just note it was mentioned, along with those caveats from the source.
Got it. Mentioned, but maybe not directly applicable. Now, the source material makes a point of contrasting this whole situation, a claim apparently falling apart because of a clarifying declaration, with other tactics allegedly used in the case.
That's right. It draws a sharp contrast. On the one hand, you have Vituscka's sworn declaration, which the source presents as clear and direct.
And on the other hand,
the source describes other evidence used in earlier filings with phrases like blurry, inaccurate texts.
blurry texts.
Yeah, or cutting out dates and context from messages to make them seem like they mean something different or more damaging than they actually did.
So the comparison the source is drawing is clear corrective declaration versus allegedly murky or manipulated evidence presented previously.
That's the stark contrast presented in the source materials discussion, highlighting a perceived difference in how information has been presented to the court by different parties or at different times.
Okay, let's shift to another major development the source discusses, stemming directly from Vituscka coming forward. There's an agreement about communications.
Yes, this is another really significant piece detailed in the source. James Vituscka has agreed to voluntarily turn over communications.
Voluntarily, so not forced by the court.
Exactly. The source emphasizes the voluntary aspect. He's agreed to hand over all his communications where Bryan Freedman is a party.
All communications involving Bryan Freedman. That sounds broad.
It does. Potentially quite revealing.
What's the time frame for these communications according to the source?
The source specifies the period is from July 2024 through January 16th. And given the context, that January date is likely 2025. So about 6 months of messages.
July 2024 to January 2025. Any communication between Vituscka and Freedman during that window, what does Vituscka get for agreeing to this?
In exchange for providing these communications voluntarily, the source explains, Vituscka will no longer be deposed by Leslie Sloane's legal team.
Ah, so he avoids a deposition. That's the sworn questioning by lawyers before trial, right?
Correct. So instead of sitting for hours of potentially tough questions under oath, he provides the documents that, presumably, contain the information Sloane's team was after, and maybe more.
Seems like a strategic trade as the source presents it. Give them the documents, skip the hot seat. But the source discussion flags something really interesting about the start date, July 2024.
Yes, this is a key point raised for speculation in the source material. It notes that Bryan Freedman reportedly wasn't even officially hired by Wayfarer or Baldoni back in July 2024.
Hold on. The communications being turned over start before Freedman was officially representing the plaintiffs in this case.
That's the explosive detail highlighted in the source. It immediately raises the question, what were Vituscka and Freedman talking about before Freedman was formally on the case?
Yeah, what could that reveal?
The speculation in the source is that these pre-engagement communications might shed light on early strategy discussions, planning, maybe coordination that happened before the lawsuit was even filed, or before Freedman officially took them on as clients for this specific matter.
That's fascinating. Pre-lawsuit chatter, potentially. And the source also points out a crucial legal thing about these specific communications, given Vituscka wasn't Freedman's client then.
Absolutely critical point. The source highlights that because Vituscka was not Freedman's client during this period, there's no attorney-client privilege covering these messages. Meaning those communications aren't legally protected as confidential in the way that discussions between a lawyer and their actual client usually are. Same goes for work product protection, which shields materials prepared for litigation.
So, let me get this straight. The source says Vituscka wasn't Freedman's client, so their messages aren't privileged, even if maybe other Wayfarer people were copied?
That's the legal point being made in the source, yes. The lack of that direct client relationship for Vituscka means these communications are essentially open, discoverable, not hidden behind the usual legal shields.
And now they're being voluntarily handed over. The source also contrasts this voluntary handover with other attempts to get information in the case, right?
It does. It specifically contrasts Vituscka just agreeing to provide his messages with, for instance, a mention elsewhere in the case where Judge Lehman apparently denied a subpoena trying to force someone else, in Edgeworth, to provide information.
So voluntary versus court-compelled, which didn't work out in that other instance mentioned.
Exactly. It highlights the significance of Vituscka choosing to provide this potentially sensitive information.
And the source uses some pretty colorful language to describe the significance of this whole agreement, doesn't it?
Oh yeah. The discussion describes this development as a chef's kiss.
A chef's kiss, like perfectly done.
Sort of suggesting it's a particularly satisfying or well-executed turn of events, especially perhaps from Sloane's perspective, as presented in the source. It also uses the phrase that the deposer becomes the deposee, referring to Bryan Freedman.
The deposer becomes the deposee because Freedman, the lawyer who would normally be questioning people, deposing them, might now have his own communications examined.
That's the implication captured in that phrase from the source. It suggests that turning the tables, potentially putting Freedman's own interactions under the microscope, especially given the earlier point about how Vituscka reportedly felt his messages were misused.
Right, a bit of poetic justice, perhaps, as viewed in the source. Okay, so we've got the declaration itself gutting the claim against Sloane, the potential Rule 11 follow-up for fees, and now this major agreement for Vituscka to hand over potentially unprivileged communications involving Freedman, starting even before he was hired. This leads us to the bigger picture implications the source discusses.
Exactly. The source doesn't stop at just the Sloane claim. It uses this whole episode to ask much bigger questions about the entire lawsuit filed by Baldoni and Wayfarer.
What kind of questions?
The main one, prompted by how the Sloane claim apparently fell apart, is how much of the rest of this lawsuit might be built on similar shaky ground? Like, is it filled with other instances of twisted evidence, as the source puts it, that won't actually hold up?
So the concern raised in the source is that the Vituscka-Sloane issue might not be an isolated incident, but could be representative of a wider problem with the evidence or how it's presented in the case.
That's the doubt being cast, yes. If this core accusation could unravel so spectacularly, what about everything else?
And the source goes even further, exploring the potential real purpose behind filing the lawsuit in the first place, suggesting it might not just be about seeking damages in court.
Yes, this is a significant perspective offered in the source, that maybe winning in court against defendants like Leslie Sloane, the NYT, Ryan Reynolds, wasn't the primary goal.
So what was the goal, according to this view in the source material?
Several possibilities are floated in the source discussion. Things like using the lawsuit to retaliate against Lively.
Retaliate for what, does it say?
The source doesn't detail the why in the snippets we have, but the implication is there's some underlying conflict. Other suggested motives include using the suit to further their smear campaign against certain people, to intimidate witnesses who might have damaging information,
Well,
and ultimately, maybe not even planning to take it all the way to trial against everyone, but to use the pressure of the lawsuit to force Lively into settlement.
retaliate, smear, intimidate, force a settlement. Those are incredibly serious accusations about the motivations behind a lawsuit. Reported directly from the source material, it paints the lawsuit as a weapon, basically.
That's the picture painted in that part of the source discussion, yes. A strategic tool for ends other than just seeking justice for the stated claims.
And where does this leave Bryan Freedman, the plaintiff's lawyer, in the source's view?
Well, there's speculation discussed in the source that these developments, stemming from Vituscka, make it more likely that Freedman could be removed from the case.
Removed? Why would this lead to speculation about him being taken off the case?
The source connects it to the implications of the Vituscka Declaration and the comms agreement. But it also brings up an interesting comparison. Apparently elsewhere, the plaintiff's side had pointed to, say, Taylor Swift's team voluntarily providing info without a subpoena as being cooperative.
Okay.
So the source discussion questions the consistency. If voluntary production is fine there, how do they handle Vituscka voluntarily producing potentially damaging, unprivileged communications involving Freedman himself, especially from before he was even hired? The source suggests this perceived inconsistency, plus the issues with the Sloane claim itself, fuels that speculation about Freedman's position.
Interesting point about perceived consistency raised in the source. It also briefly touched on another case, didn't it? Jones v. Abel.
Yeah, a quick mention. The source discusses whether the Vituscka Declaration might help in that separate Jones v. Abel case.
How so?
The idea raised is it might help clear Sloane, specifically on being the source of the sexual abuser claim related to Jones. But the source is careful to say it probably doesn't clear her on other things she might have said or done regarding Jones. So maybe limited help there.
Okay, a potential small ripple effect, noted with caveats. The source also gets into the money aspect, right? The cost of all this.
It does. There's a detail mentioned where the context suggests Mr. Sarowitz, who's reportedly funding the litigation, is discussed as potentially paying millions for this sloppy work with blurry, inaccurate texts.
Millions for sloppy work, that's harsh.
It reflects a view in the source that a lot of money is being spent on a case that, at least in parts like the Sloane claim, seems built on shaky or poorly presented evidence.
And there was that analogy.
Oh yeah. The source discussion sums up this view by saying the receipts turned out to be toilet paper.
Oof, receipts turned out to be toilet paper. That's incredibly dismissive, suggesting the evidence, despite the cost, is basically worthless in the source's view.
It definitely conveys a strong judgment from the source about the quality and substance of the evidence presented by the plaintiffs, or at least the value for money being achieved.
Now, the source material raises some really serious questions about media leaks. This sounds potentially explosive.
Yes, this part of the source discussion is quite intense. It raises direct questions about whether Bryan Freedman himself might have been leaking negative information about the case to the media.
Leaking to whom?
The source discussion specifically mentions the Penske media monopoly and the Daily Mail as possible recipients of these alleged leaks.
And what would be the purpose of allegedly leaking negative info, according to the source?
The suggestion raised in the source is that it might have been done deliberately to, quote, create a shitstorm.
Okay, why?
The source suggests the goal might have been financial benefit by filing frivolous lawsuits. So stir things up publicly, create chaos, then use that atmosphere as leverage or justification for lawsuits that might bring financial rewards, even if the suits themselves are weak.
Okay, that is an extremely serious allegation discussed in the source. Deliberately leaking to foment chaos and then filing potentially frivolous suits for profit. And the source asks about consequences.
It goes there, yes. The discussion raises the question. If this alleged behavior were true leaking info to create a storm to enable filing frivolous suits for money, could that be grounds for being disbarred?
Disbarred from practicing law.
Yes. Or even the source asks, could it step into RICO territory?
RICO, like the Racketeer Influenced and Corrupt Organizations Act for organized crime.
That's the one. Again, crucial to stress. These are extremely serious questions and allegations raised within the source material. We are reporting what the source discusses, not stating these things as facts or our opinions.
Absolutely critical distinction. These are points raised in the source discussion about potential ramifications if certain alleged actions occurred.
Precisely. We're just conveying the content from the source, impartially.
Okay. And finally, the source used some vivid analogies to describe the whole mess as it sees it now.
It did. To capture the perceived state of the plaintiff's strategy or situation after these developments, the source discussion used analogies like, the snake is eating its own tail.
Meaning self-destructive.
That's the implication. Or another one used was that the snake's head is not attached to its body.
Lack of coordination. Disarray.
Something like that. Both analogies from the source suggest a situation that's become internally conflicted, incoherent, or is somehow working against itself based on the perspective presented in the source material.
Right. So quite a journey we've taken in this deep dive. Based entirely on the source material provided, we've unpacked the Vituscka Declaration.
How it seemingly corrects the record on that key claim against Sloane about the timing and source of the sexual abuser comment.
Which, according to the source, appears to just decimate that specific defamation claim, making it dead, deceased, over.
Leading to the strong likelihood, discussed in the source, of Sloane seeking legal fees via Rule 11 for a frivolous claim.
And then the huge development. Vituscka agreeing to voluntarily hand over potentially crucial, unprivileged communications with Bryan Freedman.
Including messages from before Freedman was even formally hired, a move the source called a chef's kiss, and suggested turns the deposer into the deposee.
And we explored the broader questions this raises in the source. Doubts about the rest of the lawsuit's evidence.
The serious allegations discussed about the real strategic aims, retaliation, smear campaigns, intimidating witnesses, forcing settlements.
The speculation about Freedman's position, the millions for sloppy work critique, the toilet paper receipts analogy.
And those really heavy questions raised in the source about alleged media leaks and potential consequences like disbarment or even RICO.
Phew. By digging into the details provided in the source material, we've hopefully given you a much clearer picture of these complex turns, understanding the context, the significance, and the potential implications discussed.
It really shows how one document, one agreement, viewed through the lens of our source material, can send major shockwaves through a high-profile case like this.
Absolutely, and it hammers home how crucial it is to look beyond the headlines and initial claims to see what the actual filings and subsequent developments reveal. This declaration and agreement didn't just tweak one part of the case. The source suggests they call the plaintiff's entire strategy into question.
It's a potent example of how the legal discovery process declarations, document production, can really pull back the curtain on the dynamics and potential motivations at play.
It really does, and it leaves you wondering, doesn't it? As these communications Vituscka agreed to provide are examined, what other hidden strategies, what prior discussions, what alleged motivations might come spilling out into the light?